Thank you so much for tuning in to Kirk TV. Kirk Mid Morning is the program with me, Faith Kalu. Thank you so much for joining us this 30th day of August 2022. Such a big day right here in Kenya. Of course, we're expecting to cross over to the Supreme Court any moment from now once the pre-trial conference commences. So keep it Kirk TV. But right about now, let's focus on Kirk Mid Morning this blessed day. I hope you're doing well wherever you are. Keep it warm because indeed it is a chilly day. Remember, do interact with us on our social media platforms, Kirk TV Kenya on Facebook and YouTube. Let us know where you are watching us from and what are your thoughts on the presidential election petition. Of course, today is the pre-conference day hearing expected to begin tomorrow and the verdict to be out on the 5th day of September. Of course, it is going to be a very busy week. All eyes on the Supreme Court on the case hearing. So definitely do keep it Kirk TV because we'll be bringing you those ongoing live right here as well as discussions based on what will be happening. But as of now, as of today, let's focus on Kirk Mid Morning. Of course, later on, I'll be looking at the Supreme Court battle, or rather the pre-trial conference day, and have a look with my guest in studio who I'll be introducing in a few, talk about that and touch on what is expected from today's pre-trial conference. However, right about now, let's have a look at some of the news update. We start with the news from Rongai in Nakuru from the by-election. Now, Paul Chebor of the United Democratic Alliance Party is the new Rongai member of parliament elect. Chebor trounced his closest competitor and incumbent member of parliament Raymond Moi to clinch the seat. Chebor garnered 27,021 votes in the election, with Moi, who was vying on the KANU ticket, coming in distant second with 14,715 votes. Former RMP Luke Kigen was third with 593 votes. Moi was seeking a third term in office after having served for the last 2 consecutive terms. Now speaking after being declared the Rongai MP-elect at Nakuru Technical Training College, Chebor pledged to work closely with his competitors. Now, Wiper Party's Mwalika Mboni has won the Kitui Rural MP race. The incumbent won re-election with 19,745 votes against UDA Party's Charles Mutisia Nyamai, who garnered 10,178 votes, with an election that saw a voter turnout of 54.57%, with a total of 30,089 votes cast. MP-elect Mwalika ran on a CCU ticket in 2017. This is before defecting to Wiper ahead of the 2022 general elections. Well, still on the by-election matters, we shift gears to the gubernatorial races. Now, ODM Party's Fernandez Baraza is leading against Cleophas Malala of Amani National Congress ANC Party in the Kakamega gubernatorial race. In Mombasa, ODM's Abdul Somad Nasir is leading UDA's Hassan Omar in the hotly contested gubernatorial race, with only 2 constituencies left to declare the final results. Well, let's now shift gears, have a look at the Supreme Court, which has rejected 3 applications, including President-elect William Ruto's request to bar the Law Society of Kenya from being enjoined in the 2022 election petition. The court has also struck out the petition from former Gatundu South Member of Parliament Moses Kuria. This is together with former Mbeere South Member of Parliament Geoffrey Kingangi, who had filed a petition urging the Apex Court to throw out Odinga's suit. The court has also rejected the application by Agano Party leader David Moure to be enjoined in the case. Application by John Walubengo, Dr. Joseph Sivila, and Martin Mirero seeking to leave to be joined in the petition as Amica Ekuri has been allowed. Also allowed was the application to admit on record the replying affidavits of Juliana Cherera, Justice Nyang'aya, Francis Wenderi, and Irene Masit, which Ruto had opposed.
All expecting the hearing of the presidential election petition, and starting Monday, from Monday 22nd of August this year, the petitioners filed a total of 9 petitions. By Saturday, last Saturday, 27th of August, all the respondents had put in their responses. And as at yesterday evening, we had the petitioners again file all their rejoinders. So all the filings have been done. All the 7 judges are expected to participate. Remember, in the last season, we only had 6 judges participating. This time round, we expect all of them to be present. We have some observers, judges from the Commonwealth countries led by the retired Chief Justice of Tanzania, Honorable Mohamed Othman. We are expecting that every team will be allowed only up to 4 lawyers. It is still being negotiated, and we're expecting that the guidelines will be provided anytime now.
29 minutes past 10 a.m. We are taking a very short break. Do keep it right here, because when I come back, I'll be joined by an advocate of the High Court, Odhiambo Brian Otieno, to take us through the discussion of the pre-trial conference day, getting to understand what it's all about and what to expect. So keep it Kirk mid-morning. We're taking a very short break. We'll be right back.
Are you looking to grow your business? Kirk TV offers you a variety of advertising opportunities to suit your budget. Advertise with us today and reach your potential customers countrywide. For more information, email us on sales@kirktv.org or call 011 00 90 647.
When the Bible wants to say something has come to an end, they'll say they waited for 40 years, for 40 days. 40 is an end of a season.
40, if you read the Old Testament, and it even overflows into the New Testament, is fullness.
You know, something continuous, not just because it's 40 years.
To me, is the victory of the church, that the church was able to embrace women.
And so we also celebrate the many men, the many leaders, our church fathers, who actually sat down and said it is time.
It's a moment of rejoicing over the joys and pains that I've gone through.
And I told God I would want to be a minister like this one.
The ones that cleared the thicket in the forest for us.
Because of the sacrifices they made, the battles they fought, you know, their great commitment.
In all humility, there are those who have been called home. They have paved the way for us.
To be with the Lord home, Jesus is still with you.
No Jesu areho rogendo ni ruega
totwa ranete hegi keno.
Choose life that you may love the Lord your God.
If you delight yourself in the Lord, He will make you fruitful in whatever season you are in.
Listen to His voice and hold fast to Him.
That as disciples ourselves, we're being invited to be transformed more fully every single day.
In our walk with God, let us know that we are assured victory in every battle.
For the Lord is your life.
Live a pure life. Are you living a righteous life before the Lord? It is possible. People are wondering, can you do without corruption? Yes, I can stand and say it is possible to do without corruption.
Don't miss season 2 of the evening epilogue every day at 9:30 p.m. only on Kirk TV.
So catch Fit to Live every Monday through Friday at 6:30 a.m. and 4:30 p.m. Together, let's have fun, get fit, and stay healthy. My name is Aida Munzati. I'll be your host for this show. Remember, your health always matters.
Where there is no vision, the people perish.
You'll find people talking about saying, we discussed this for the last 5 meetings or for the last 2 years or 3 years, but nothing seems to move.
Here on Effective Manager, we help you get leadership and managerial tips.
You cannot be popular in the workplace as a leader. You can only be respected because of being fair and providing leadership.
Strategy and board advisory.
You do not need to put in unnecessary and undue pressure.
Stimulate new ideas in leadership and management.
You get an opportunity to bring diverse views and ideas to a problem so that you can be able to identify a lasting solution.
You can't afford to miss The Effective Manager with Dr. David Muturi, Wednesdays at 7:30 p.m. only on Kirk TV.
The application of the law does not select the rich or the poor.
People are supposed to take responsibility for their lives, but society has always looked frowned upon it.
Here we educate you on the laws of the land.
Adoption does not have so many hurdles and so many laws, and it's not difficult.
Matters related to administration of justice.
It's very difficult for you to inherit from an estate of a deceased if you're not a child or a bona fide wife.
Cover crime related topics.
Issues of torture are criminal issues that the government will take very stern action.
And many, many more.
Leave your worries with the lawyer. Let them go through, let them worry about how you will answer your questions. Let them worry about what you will say in court. They will guide you.
Sometimes the law is very difficult, but you have judges now to interpret the law.
Don't miss Know Your Laws Thursdays at 7:30 p.m. only on Kirk TV.
So catch Fit to Live every Monday through Friday at 6:30 a.m. and 4:30 p.m. Together, let's have fun, get fit, and stay healthy. My name is Aida Munzatsi. I'll be your host for this show. Remember, your health always matters.
When the Bible wants to say something has come to an end, they'll say they waited for 40 years, for 40 days. 40 is an end of a season.
40, if you read the Old Testament, and it even overflows into the New Testament, is fullness.
You know, something continuous, not just because it's 40 years.
To me, is the victory of the church, that the church was able to embrace women.
And so we also celebrate the many men, the many leaders, our church fathers, who actually sat down and said it is time.
It's a moment of rejoicing over the joys and pains that I've gone through.
And I told God I would want to be a minister like this one.
The ones that cleared the thicket in the forest for us.
Because of the sacrifices they made, the battles they fought, you know, their great commitment.
In all humility, there are those who have been called home. They have paved the way for us.
To be with the Lord home, Jesus is still with you.
No Jesu areho rogendo ni ruega totwa ranete hegi keno.
Welcome back, and thank you so much for keeping it Kirk Mid-Morning with me, Faith Kaulu. Just a reminder that we are celebrating the 40 years of clergy women in ministry in the Presbyterian Church of East Africa. My colleague Vincent Kerosi, of course, will be joining us with Reverend Leah Ndegwa talking about matters of entrepreneurship, of course, with a focus as well about her ministry and how she's able to handle all that. But today, our topic of discussion is the Supreme Decision, the pre-trial conference, and joining me is Odhiambo Brian Otieno, an advocate of the High Court. Thank you so much for being here today, Brian. We appreciate it. It's quite a chilly morning. Thank you for making time and braving the cold weather in Nairobi. You know, so Mr. Odhiambo BO, yes. Karibu sana. Let's start to have a look at the presidential election petition. Of course, we saw the declaration by the chairperson Wafula Chebukati, yes, on the 15th. On the 16th, Raila Odinga of the Azimio la Umoja in Kenya came out to denounce the declaration of the presidential election. Of course, now Kenyans anticipating a petition, which of course happened. And here we are, the pre-trial conference expected to start any moment from today, of course, at around 11 a.m. Yes. Let's talk about the pre-trial conference, because I believe Kenyans will be glued to their screens, eagerly waiting to hear what's going to happen. Let's begin with, of course, hearing your opinion, first of all, on what do you make of the presidential election petition 2022?
First and foremost, thank you for having me around.
with regards to the presidential election petition, as advocates would say that this is an opportunity again for us to develop our law, our jurisprudence.
Yeah.
Because if you look at how these elections were conducted, they were conducted in tandem with the decision in 2017.
Right.
So this is also an opportunity for us again to inform how subsequent elections would be conducted. It is a chance for the Supreme Court to pronounce itself on great issues in terms of technology, in terms of composition and composition of the IEBC, and how accurate IEBC should be when the declaration of the results should be made. So it is another opportunity for the Supreme Court to shape the jurisprudence of this country and develop our legal framework as a country. Yes.
And speaking about that, of course, in comparison with the 2017 election petition, having a look at this, if you're able to preempt, what would you say are some of the issues that the judiciary will highlight?
Yeah, I don't want to preempt, but fundamentally, the major issue, of course, would be that to determine whether the elections conducted in 2022 on the 9th of August were conducted in total adherence of Article 81 of the Constitution of Kenya, as well as the Elections Act 2012 and other enabling provisions of the law.
Right.
That is the first issue. The second issue would then again be to determine whether there were any errors in the conduct of this election, and if those errors substantially affected the outcome of the election. The other issue again would be, this issue had already been canvassed in 2013, whether the determination of the 50% plus 1 should take into consideration the spoiled or rejected votes. The other issue again I would also preempt that the Supreme Court would look into is the input of technology with regards to the fact that this election is a hybrid process. It is reliant on both the manual and technological aspects. How would the influence of technology impact on the issues of verifiability, transparency, a simple and accurate electoral process? Again, the other issue, the final issue I think would be on the issue of IEBC and its composition. Is the declaration of a presidential result or outcome an entire function of the commission or a preserve of the chairperson alone? Yes, there's a question of the chairperson being the national returning officer.
Yes.
But is the declaration supposed to be a commission result or a commission declaration? So that distinction again should come out clearly. That is an issue that we presuppose the Supreme Court would come out clearly on. Yes.
And speaking about that, because of course it is a highly, can I say, contested area, where of course people don't quite understand what is stipulated in the Constitution. Of course, everyone has their own interpretation, whether it is the responsibility of the chairperson as the national returning officer or the responsibility of the whole members of the commission. What is your understanding of that?
Yeah, my purposive interpretation of the law is that the body mandated to conduct and manage elections is the Independent Electoral and Boundaries Commission. And it means that there is an organ called the commission. The commission is the supreme organ of IEBC.
Right.
The commission is headed by a chairperson. The chairperson is not separate and distinct from the commission. He is only would say the director, the managing, the person who leads from the front. But the law again outlines that he is the national returning officer. Now, this distinction is a bit gray because we need clarity on it, and that is why we are before the Supreme Court at this moment. Because it would be foolhardy for me to presuppose and say that it is a preserve of it. This is how it should be interpreted. Now, that is why we are invoking the role of the Supreme Court to advise us on how to interpret this aspect. Because the result, is it supposed to be the commission's result or the chairperson's result? But my thinking is that the commission is the body mandated to conduct elections. Now that tallying should be that tallying process and verification process is a preserve of the commission. What the chairperson is supposed to do is to declare. So the chairperson should declare a result emanating from the commission.
All right.
Not his own personal results. That is the simplest and basic understanding of the law as it is.
Okay.
Yes.
So of course we're expecting to have an outcome that would play an integral role in the upcoming general election?
Yes, absolutely. So that in 2027, we wouldn't see a scenario where the commission is divided, as we saw.
Right.
We have four, the other three, including the CEO, on the other end, saying that we own these results belong to the commission. These other four are saying that we disown those results. And that again would help us entrench values, the national values and principles in Article 10 of our Constitution, where state officers are required to operate in a manner that is honest. State officers are required to operate in a manner that promotes democracy and the rule of law. So that is our anticipation, so that by the time the Supreme Court determines on this issue, there's clarity, so that in 2027 we don't have a scenario where parties or individuals in the commission are divided.
Right.
We have a commission as it means, a commission.
Okay.
Yes.
I'm tempted to go deep into talking about, of course, the division that is there. I think we will come later to that.
Absolutely.
Let's look at the pre-trial conference today.
Yes.
Of course, to encourage our viewers to interact with us on our socials, Facebook and YouTube is Kirk TV Kenya. In case you have any questions, leave it down below. We'll have a look at them, and of course, Mr. Dembo will help us understand them better.
Yes.
But just to set facts clear to Kenyans who, of course, I believe will be glued to their screens expecting to hear what is going on. Here's a question. Is the pre-trial conference the beginning of a hearing, or what is expected to happen today? Just for viewers to have an understanding.
That's a very good question. Now, a pre-trial conference is a standard procedure in any legal process, be it a criminal or a civil suit. It's a standard procedure premised on the principle of overriding objective. This principle presupposes that the courts have a duty to determine suits or cases or matters in a manner that is fast and expeditious, and at a proportionate cost. Now, a pre-trial conference is basically, in the simplest terms, is a preliminary meeting between parties under the guidance of the judges, where few issues are aligned. Now, this is what happens in a pre-trial process. In a pre-trial conference, parties come together, the court pronounces itself with regards to the issues that will be subjected to determination, so that we do not have so many issues. Some of them are non-issues, or some of them are little weightier. So we have an alignment, a determination of the issues that are major and need to be determined at the very onset. So the other issue that happens during a pre-trial conference is that parties there's a management in terms of who and how people should present. This is a scenario, like in this case, you have a team where there's a team that has 54 lawyers. There's a team that has 30 lawyers. The other teams also have their representation.
Right.
Absolutely, not all of them will present before the court. So the court will set directions with regards to who, the number, and for what time, for how long will they present. The other issue, the other thing that happens during a pre-trial conference is the determination of how to handle evidence. Okay. There may be electronic evidence. Parties will then engage on how to present, whether that electronic evidence itself is contested. These are issues that will be ironed out during the pre-trial conference. And I think finally the other issue would be the determination of how long parties will be on their feet, so that we do not convolute time. We do not end up convoluting issues and allow somebody to present. So there's a setting of times and timelines in terms of presentation.
Okay, so it's basically like a house meeting, trying to set everything in order and all that.
It's doing a checklist.
Yes.
Sort of a checklist to ensure that when we now go into full-blown hearing, we now understand the rules of the game.
Okay.
Yes.
One may ask, why is it necessary? Because of course, probably today could have been used as day one of a hearing, looking at we have a limited time. So why is it necessary to have the pre-trial conference?
The most fundamental thing why this is necessary is that you need to appreciate that a presidential petition is to be conducted within a fixed period.
Okay.
There's a time limit within which the presidential petition is supposed to be conducted. the time is indeed limited, and so we do not want the court is trying to secure itself from a scenario where we subject ourselves into a long hearing in total abhorrence of the constitutional time limits. Okay, so what happens is that it is proper for the court to set these rules and then allow people go into the full-blown hearing without delving into the preliminary issues.
Yes.
Yes.
Rather without any interruptions.
Without any hiccups.
Okay.
Yes.
Let's talk about how things are likely to play out today. You mentioned that, of course, they'll have a look at what's weightier, what's likely to be thrown out, if that's the right time to use. How's it likely to play out today? Is a legal mind what?
Yeah, that is likely to come in play today. But what happens in such a scenario, it is very clear that there are issues that are not contested with regards to whether the election in 2022 was conducted in respect, in total adherence with the provisions and elections. That is Article 81, the Elections Act 2012, and other acts, and even the Supreme Court rulings in 2013 and 2017. That is a fundamental question. The other issues probably may be contested, but these issues are incidental to the determination of whether the 2022 election was conducted in respect of the law. So they probably will emanate from the major issue, and then we'll have other issues again coming from the major issue. I also failed to point that during the pretrial conference, applications by parties that are not the major parties, this is where the phrase amicus curiae comes in, are heard and determined. This morning, how the 2022 petition has opened up space. You'd notice that the Honorable Lady Chief Justice Home has opened up space for amicus. She has allowed so many to come in, as opposed to what happened in 2017 and 2013.
Right.
This time around, so many people have made applications, and the decisions on these applications were even rendered today in the morning. The Law Society of Kenya was allowed to come in. The International Commission of Jurists, ICJ, was allowed to come in. And there are also 3 people who are technology experts who have been allowed to come in. So, yeah, this is what we'll play today. Just a discussion on what issues should be framed, how much time do we need, and how will we proceed? Just procedural matters. Yes.
Are we likely to see any petition probably not holding water?
Yeah, that has already played out. You remember there were 9 petitions that were filed before the Supreme Court.
Right.
But now we have reduced them to 8. The petition by Moses Kuria has been thrown out. Yeah, I've not had the opportunity to read the reasons for that, because they are yet to be released. But once they do, we will get the rationale of the court, because Moses Kuria was petitioning against
the presidential election. Yeah.
Yes, alleging that he was engaged in electoral malpractices. So yeah, these are issues that probably we will get to know in the course of time. Yes.
Okay. There's the issue of the lawyers. You mentioned that, of course, we have 54 lawyers, 44 in another camp. Not all of them will be allowed to speak or represent. What then does this mean for, all those lawyers that have been hired, and then here's a few number that is allowed?
Of course, in an ideal scenario, everybody wants to talk. I know my colleagues with submissions. People, we love speaking, because that is our tool of trade.
Right.
But then again, we have to be open to circumstances. We have to understand that what is actually happening. The extenuating circumstances have to determine the approach we take. Now, first of all, there's a time limit with regards to the examination of the presidential petition. So you cannot allow 54. I would want to imagine how much time would 54 lawyers, for instance, take to present. That is why even before that communication was issued, the Azimio Brigade was advised to reduce its petition to 40 pages, which they did, because there's no need to have a very huge document while appreciating the circumstances of time. So yeah, it is important that we, even as we make decisions, even as we all desire to talk and present ourselves and make our cases, we appreciate the circumstances in which the Supreme Court finds itself in. the issue of time limit, it's purely an issue of respecting the constitutional time limits. Yes, so that we do not waste time having so many people at their feet.
Yes.
And it's also very possible that what I would say as lawyer A for the petitioner would probably be repeated by lawyer C for the petitioner.
Indeed.
Yes.
Okay. Of course, just remind you, dear viewer who's watching us, any moment we'll be crossing over because activities have begun. We're expecting the pre-trial conference to begin any moment from 11 a.m. So we'll be letting you know how that plays out. This is the first time that the Supreme Court is being asked to declare a presidential winner. Of course, after a returning, if that is even a possibility, let us know. Let's look at that. Is that a probability? Is that something that is likely to happen?
Of course, a petitioner makes their prayers before court. Now, the fundamental question would be, can the Supreme Court declare president, and on what basis? So if the Supreme Court would want to declare president, it has two options: to either conduct a retally or a recount. Now, these are two different issues. A retally is premised on now the existing Form 34As, which are already contested.
Yes.
Parties, the petition is contesting the authenticity and the veracity of the Form 34As. A recount means going back to the ballot papers as they are and sealed, where IBC has kept them, in the presence of designated agents of both parties, counting them physically. Now, the Supreme Court can make orders consequential if it wants to meet the ends of justice. That is the question. That is the law allows it to do so. But now the question would be, this would come clearly in the course of submission. Is it really necessary to go that way? Yes. So we cannot preempt that the Supreme Court would do that.
Okay.
But based on how parties seek their prayers, parties can seek their prayers, but they have to support why they're seeking those prayers. So we expect the petitioner now, for instance, in this case Raila Odinga, to make a case why he is seeking to be declared a president by the Supreme Court, and why, if that declaration would have basis in law, in both fact and law.
Right.
Yes.
Okay.
Yes.
And of course, if that prayer is, I'd say, taken into consideration, and the order, whether a retally or, of course, a recount of the votes, we're also looking at the limited time that is there to do all that, and have that also be part of what will influence the verdict that will be given out. So when we look at, of course, the time constraint factor, and we look at, this is not an activity that would last a few hours. Of course, it needs days to do that. You know, from your point of view.
Yes, and again, if you look at the powers of the Supreme Court in terms of presidential-led petitions, the law is not clear whether they are allowed to declare somebody. The law is not clear. The framing of the law is that where an election is contested and it is proven that the errors substantially affected the outcome, then the express and immediate thing that should be done by the Supreme Court is to order a fresh election. That is the requirement of the law. Within 60 days. The issues of declaration, recount, and retally may be quite far-fetched in terms of how the law is currently framed. Okay? But the Supreme Court, we have to appreciate, is allowed by law to make any consequential orders. So we can't preempt if they will make such consequential orders.
Right.
Yes. But the law as framed, is that they have two options. The consequential things that are likely to come out in the event of a conclusion of a hearing of a presidential petition are two. The affirmation of the president-elect, then he's supposed to be sworn in within 7 days. The declaration of a runoff, of a fresh election, to be conducted after 60 days.
Right.
That's simple. So the issues of a recount or a retally or a declaration, those are subject to the determination of the court. Yes.
Okay.
And that should be done in line with their powers under the Supreme Court Act and the Constitution. Yes.
You've mentioned about a fresh election or a repeat of election. Of course, one of the prayers as well of Raila Odinga's petition is to declare the chairperson Wafula Chebukati unfit to hold office. So if this is taken into consideration, and then of course the court orders a repeat of election, how's this going to play out, considering that of course he's the national returning officer?
Of course, we have to appreciate that the moment when parties to a duel, or as in this context, the elections context, impugn the suitability of the referee, then that already throws into disarray whether that person is suitable to hold office. Now, if the court were to ask for a fresh election to be conducted, then the fundamental question would be, is IEBC, as currently constituted, able to conduct an election based on the principles, electoral principles in Article 81, verifiable, accurate, simple, and transparent?
Yes.
That would be the question. The buck now falls with Parliament, okay? Because Parliament, the IEBC is an appointee of both the President and the Parliament. There's a vetting process by the Parliament. The buck now stops with Parliament. Now, 60 days is enough time to reconstitute an election, an election body. But we don't want to preempt again. We just have to wait and see how things play. But then again, it would be sensible that the moment parties to an election find an individual feel that the referee is already biased, it would be sensible to change the referee. But this goes again into the long-term question of whether is IEBC actually independent? Is the press independent, actually standing to test? These are questions that probably scholars would want to delve into after the election petition, and question whether is IEBC serving its purpose. The framework of IEBC as is currently, both in law and in practice, is it really serving to secure the country from these issues of contested elections where we came from in 2007? That is a question, again, we should be responding to post this petition.
Okay.
Yes.
Let's have a look at IEBC, because of course we're here now putting them on spot.
Yes.
And we know that of course there's a division in the Electoral Commission. The 4 commissioners have their own affidavits in court. We have the chairperson, of course the other 2 commissioners rather, as well as the CEO. Yes. Let's look at Deputy President, or rather President-elect's, one of his prayer was to not allow the 4 commissioners, to bar the affidavits of the 4 commissioners, which rather the court has not considered, meaning they will be heard, they will be allowed to make their petition as well. So let's look at what kind of picture does this paint? Of course, these are members of the same Electoral Commission.
Yes, you need to appreciate that, yes, we are in a very novel setup. This is something that has never happened, I think, in Kenya. Probably it may have happened somewhere. But yes, the Deputy President, in an application, contested the fact that all the commissioners were listed as respondents. And his argument was that they are probably positioned and disguised as petitioners, or rather than being respondents, because they're basically supporting the petitioner's case. In fact, he wanted all these affidavits by all the 6 commissioners to be expired, not limited to the 4. He wanted all of the 6.
Right.
This application was disallowed this morning because the court was of the argument that they participated in the election, and for the full and fair determination of this matter, it is important that all parties be heard. Now, at the filing of a suit, a petitioner lists the respondents. Okay, it is the law allows, the civil procedure allows you to list any party you feel will help the court in determining the suit. Any party that is party to the suit. So you could list up to 100. Okay. You could list up to 20. All of them need to respond to the allegations levied against them by the petition. So the question of whether they're responding to or raising new issues is up to the court to determine.
Okay.
And the court said, yes, we need to hear them because they're listed as respondents. And that's simple.
All right.
Yes.
The 7 judges have already made their way, and I think right about now it's the opening statement happening. I think let's cross over, listen in, find out what is going on.
I appear for Mr. Wafula Chebukati, Chairman of IEBC. Mr. Eric Gumbo and Mr. Kamau Karori appear for IEBC.
Yeah. May it please you, Chief Justice, your Ladyship, my Lord, I appear together with my learned friend, Professor Kindiki, and learned Senior Counsel Kioko Kirukumi, and those are the 3 slots we have been allocated for the 8 petitions.
I think you are allocated for.
Yes, for the 8 petitions. So that will be the constant theme in representation for now the 3rd respondent.
You are allocated 3 counsel for the 9th respondents.
Very well.
Yes.
At least we have 1 more who will be joining us. Thank you, Chief Justice.
And for the record purpose, because we are recording the proceedings, Senior Counsel, friend Gatia, you didn't say your name. We know you, but the system may not.
Chief Justice, thank you very much.
Put the mic.
My name is Ngatia Frederick. It's my joy and pleasure to be the team leader for the 3rd respondent.
Thank you. That is all about appearances.
My Ladyship and members of the court, I've just been alerted by a senior counsel who is locked out, who should be in these proceedings. Senior Counsel Muite and Counsel Ali Mansour for the IBC. I think it's a matter which is live before that determination whether they could be had. But they have filed papers and they ought to be left at least allowed in.
Senior Counsel, they have not been disallowed. They have not been disallowed. The commissioners to IBC have not been disallowed. As respondents, they are entitled to be present with their lawyers.
Yeah, my lady, probably I'm not understood. I've not been understood by the court. There are 2 factions of the IBC, so to speak.
Both factions are allowed.
Much obliged. Much obliged.
Participate in the proceedings.
Much obliged.
With their lawyers.
So I think Senior Counsel Paul Muite should be allowed in.
Yes.
Senior Counsel Ali Mansour.
Yes.
They just told me they are not been allowed to come in.
That I don't know who read that ruling. It must be upside down, because we allowed the commissioners to participate with their lawyers. They can be called in. Any other appearance? Yes. Yes, have the petitioners introduced themselves. You know, we have petition number 1, petition number 2, 3, 4, 5. Petition number 6 was struck out.
With your kind permission, Your Ladyship and members of the court, in petition number 2, presidential petition number 2 of 2022, I am Paul Nyamodi. I appear for the petitioners, together with my learned colleague, Mr. Tom Masharia and Ms. Njoki Mboshe.
Petition number 3.
My Lady, the President of the Court and members of the Court, in this petition, my name is James Orengo, and I appear together with the Senior Counsel Philip Murgor, Paul Mwangi, Jackson Awele, Velma Auma, for respondent number 11.
My lords and my ladies, for petition number 3, Otieno Willis, I do appear for the petitioners. Maybe there was a mix-up in the numbers. For petition 3, it's Willis Otieno for the petitioners, appearing with Nelson Osiemo.
May it please you, Madam Chief Justice and the members of the court, my name is Githu Muigai, Senior Counsel. In that matter,
All right, currently happening right there, of course, the pre-trial conference coming to you live, pictures you're receiving on your screen right now. Of course, the 7 judges led by Chief Justice Martha Koome, happening as well as the introduction and opening statements of those representing the different parties. Remember, only 4 lawyers from each party has been allowed to access the courtroom today during the pre-trial conference. Also present are 11 observer judges from the Commonwealth member countries, as well as 8 law clerks who are present today at the pre-trial conference. That is what is expected to happen today. Of course, we're going to hear what petitions will not be considered, as well as any rules or guidelines that will be set for the hearing. Definitely, we'll also be bringing you the hearing as well live till the final day, the 5th of September. We expect to hear the verdict from the 7 judges, so keep it Kirk TV. Definitely, in case of any questions you have regarding the pre-trial or what you expect, leave them in our comment section. Kirk TV Kenya on Facebook and YouTube. We'll be having a look at them. In studio with me is Odhiambo, Mr. Odhiambo B.O., who's an advocate of the High Court, who is here to help us understand some of the, terms that will be used, as well as procedures and legality around issues that we need to understand, because of course this is an issue of national importance and we need to be aware and understand what is happening. Of course, we're seeing different parties introducing themselves and their legal representation. Maybe why is this an important procedure?
Yeah, it is always important for parties to introduce themselves, because court proceedings are recorded. Okay. It is also important that we know who is representing who, so that we understand who furthers the interest of which party. So basically, the reasons for introduction is just for record purposes, just for court to take cognizance of who represents who. And you'd note that There are quite a number of petitions. There are 9, and they've all been registered singularly as individual petitions.
Right.
And so going on, we would expect to see whether, after the determination of issues, or even before, whether these petitions would be consolidated to one singular petition or 2 or even groupings. So the question of consolidation also should arise in this pretrial conference.
All right.
Yes.
I think before we crossed over to have a look at what is happening, we were talking about IEBC, of course, looking at the division that is there in case of a repeat of election, what is going to happen, which of course you made us understand that very clearly. Here we have begun the pretrial conference. We understand that 4 commissioners have their own representation, as well as the chairperson, the 2 commissioners, and the CEO as well. Now, when it comes to representing the commission, so who's expected to do that? From which faction?
The ideal should be that the Attorney General should represent the commission, which is not happening this time round. It is quite a unique thing because the preserve of representing state agencies and bodies is under the Attorney General's office. But then again, they are allowed to, where the Attorney General's office is either, let's say they're all occupied, they're allowed to outsource. So I do not know how this thing is likely to play, but it seems the commission also has its own representation, different from all the entire commissioners. And that's why I pointed out earlier that this is one of the very new issues we want to see. We are seeing come at play, because this is something that it is unprecedented in this country. We've never had a scenario where the IEBC is standalone, neither is it represented by the Attorney General's office, and the commissioners themselves have gone for individual firms to represent their interest. It's quite a unique one, and we'll see how this will come into play. And as I pointed earlier, precursorily, that this would help us develop our jurisprudence so that we grow as a country in terms of our legal framework. Yes.
Just speaking of whatever determination will be made by the court, speaking about the Electoral Commission, will it come bruised, or is there, let's say, the verdict? We don't know what to preempt, but either way, depending on what the 7-bench judge will decide, is there a way that, of course, IBC will save face, or is this too bad? Either way, they are bruised.
We have to accept that where we are right now, the confidence of the country, even in the IBC as is already waned. People are now not as confident as they were in this commission. And this goes to, again, the question of whether commissions are people. Is a commission an individual? You remember in 2007, the misgivings of the electoral commission, then ECK, were attributed to one Samuel Kivuitu, may his soul rest in eternal peace.
Right.
The same things were attributed to Ahmed Isakasan. Are we going to see a scenario where the misgivings of this commission are going to be attributed again to Mr. Wafula Chebukati? So the fundamental question is Kenya ready to accept that a commission is entirely its composition? And the question would be fundamentally that what we are seeing at the moment, does it mean that we now have to go back to the drawing board and read our constitution and again appreciate that that Article 10, which I repeat every other day, on national values and principles, are not known to people? Because if we are to appreciate these circumstances, we would have not been here if we were to appreciate that as Kenyans we are bound by those national values and principles, that we are supposed to be honest, we are supposed to abide by the rule of law and democracy, we are supposed to abide by fairness and the principles of natural justice. We would have not been here questioning the authenticity of IBC's decisions.
Right.
Yes.
All right. I like how you put it. Speaking about the AG, of course, you mentioned that this is a new thing, where he's not, of course, he's come out to say he's not opposing the presidential election petition. He's not representing the Electoral Commission. We see he's part of the parties named as interest parties under the National Security Advisory Committee, which allegedly tried to influence the election outcome in favor of Mr. Odinga. This is according to how it has been stated in the affidavits of the chairperson, Wafula Chebukati, mentioning that, of course, they appeared in his office. Looking at that, and of course now he's representing the National Security Advisory Committee, comparing it to 2017 and 2013 as well, presidential election petition. What's your take on that?
Yeah, first I would appreciate that all that has been said with regards to the National Security Council is, we would term them allegations.
Right.
They are not true until proven. At the same time, these are averments in affidavit by individual people, so that we may begin even questioning their evidentiary and probationary value. Are they going to help the court in determining the fundamental question before this court? And like I said, the fundamental question before this court is to determine whether the IEBC conducted the 2022 elections in line with the requirements of the law, and whether, if there were any errors, did those errors substantially affect the outcome of the elections? So that the issues around who meeting who, in my own personal view, they are non-issues, but you can't downplay them.
Okay.
In this context, they are non-issues before the court, because the court cannot delve into meetings. The court is supposed to deal with legal issues, and that is what the court should be dealing in.
Okay.
But of course, we need to appreciate the context, the larger context, and ask ourselves again, does it mean that the National Security Council has interfered with the elections earlier? Has there been an influence in earlier elections? So that is a question that probably the court of public opinion would begin questioning. But in a court of law, our question is restricted to whether this electoral process was conducted in respect with the law.
All right.
Yes.
So we can term all these other things as sideshows.
To me, they would look like sideshows, because but we can't downplay them, as I said.
Yes.
The contested nature of elections in Kenya, especially the presidential election, where people have even coined the phrase deep state. So somebody would be asking himself, where I'm sitting as a common lay person, that is that National Security Council the deep state? The mere virtue of the fact that even the Vice Chief of General Staff has been roped into this thing speaks volumes. The question is whether do we really need to vote again? The question of, are the basic tenets of democracy in our country protected? So that if we are going to vote and there's somebody who is sitting somewhere with high authority, just waiting to influence and determine who becomes president, then probably we need to revisit Article 1, which says all sovereign power belongs to the people. That is the question we need to be asking ourselves alongside the fundamental questions, the legal fundamental questions that are going to be presented before the court today.
Okay.
Yes.
Thank you for putting it very well. When the presidential election petition was filed, we assumed that the Supreme Court has 14 days.
Yes.
But here we see today the pre-trial conference. Of course, we have 5 days, less than a week, to the day of the verdict. We're expecting to hear from all parties, to have evidence presented. Looking at the 5 days that are there, is this enough time for all of that?
Yeah, you would appreciate that this time is not enough. But then again, you also need to appreciate that the country is in sort of an air of uncertainty has clouded the country. People are not sure of what is likely to happen next.
Yeah.
So to cure this, the framers of the Constitution thought we probably need to have a specific timeline which is short and precise. And then now the Supreme Court itself can determine rules and ensure that they play within that time. You remember in 2017, the hearing would go late, even into the night. Okay? So the Supreme Court itself today will determine those rules.
All right. Sorry, allow me to cut you short. We'll come back to that. Being told that Chief Justice Martha Koome is speaking. Let's cross over, listen in, then we'll come back with you. Apologies for that.
You're very welcome. I wish to also recognize the parties who are present, the petitioners, the respondents, their friends and supporters who are watching us online. Unfortunately, due to constrained space that we are operating from, we could not accommodate very many people. You can all see we are all required to observe the COVID-19 protocols. We also have to be mindful of security and the constrained time, and therefore we were forced to limit the number of the council who can appear at any given time. But parties are free and at liberty to have as many council as they could. We'll try to accommodate as many as we can in the speed of a room, court number 1, where they can follow the proceedings and continue assisting counsel who are in the plenary. We thank the media also for coming to stream the proceedings online to assist Kenyans and all people from all over the world who are watching and following these proceedings across Africa and across the world. I want to thank the observers who have come to be part of this process to attest that we are all guided by the rule of law, constitutionalism, values that we all share across Africa and indeed in the Commonwealth and all over the world. And also to express the judicial solidarity for us, which is a core emblem which cuts across the border as we attempt to develop our jurisprudence and work together in the spirit of bilateralism and regionalism. We therefore welcome you to Kenya to these proceedings. Today, council and parties, we are here for the pre-trial of the election petitions that were filed before us. As you are aware, 9 petitions were filed, and we received 25 preliminary issues in form of interlocutory applications. We have been able to dispose of all those preliminary issues and delivered rulings online, which I believe you are still reading and internalizing. After we dealt with the preliminaries, 2 petitions were struck out. Petition number petition number E006 and petition number E009 was struck out, and the rulings were delivered together with the media summary showing the reasons why they were struck out. So we are left with 7 petitions, and the court has considered the 7 petitions which emanate from the same presidential election which was held on the 9th of August 2022. So upon perusing and considering the issues raised in the following petitions, E001, E002, E003, E004, E005, E007, and E008 of 2022, and the respondents thereto, we find that all those petitions raise similar issues and seek similar orders. Therefore, we order that petitions numbers E001, 2, 3, 4, 5, 7, and 8 of 2022 be and are hereby consolidated with petition number E005 of 2022, which is designated as the RIND presidential election petition for 2022. The parties will therefore be, the ending of the matter will therefore read as Raila Odinga and Martha Karua will be the first petitioners. John Njoroge Kamau will be the second petitioner. Youth Advocacy Africa and Peter Kilika will be the third petitioner. Kerif Karifa, John Josewe, Ruth Mumbi, Grace Kamau, David Kariuki will be the fourth petitioner. Okia Mtata Okoiti, Nyakina Wycliffe Gisebe, Victor Okuna, John Maina will be the sixth petitioner. Julia Nyokabi Chege, Joseph Mutua Ndonga, Simon Mwaura Njenga will be the seventh petitioner. The respondents will be William Ruto and Rigathi Gachagua, the first and second respondents. IBC will be the third respondent. Then Mr. Wafula Chebukati, fourth respondent. Juliana Cherela, fifth respondent. Irene Masiti, sixth respondent. Justice Nyangaya, seventh respondent. Francis Wanderi, eighth respondent. Professor Gurie, ninth respondent. Boya Moru, 10th respondent. And the Attorney General will be the 11th respondent. From the rulings that we delivered, we have admitted Law Society of Kenya as amicus curiae or amici curiae with ICJ, Mr. John Warubengo, Dr. Joseph Savira, and Martin Mirero. That is the order of the court for the consolidation of the matter. So the other issue that we are going to deal with this morning upon consolidation of the matter is to settle the issues for determination. The court, having considered the printings that were filed, the submissions, and all the documents that were filed, we have framed 9 issues that have been shared with you by now, I believe, but I'll read them out. The first issue is whether the technology deployed by IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Issue number 2, whether there was interference with the uploading and transmission of Forms 34A from the polling stations to the IEBC public portal. Issue number 3, whether there was a difference between Forms 34As uploaded on the IEBC public portal and Forms 34As received at the National Tallying Center and Forms 34As issued to the agents at the polling stations. Issue number 4, whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kacheriba, Rongai, and Pokot South constituencies, and electoral wards in Nyaki West in North Imenti constituency, and Kwanjenga in Embakasi South constituency resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. Number 5, whether there were unexplained discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 6, whether the IEBC carried out the verification, tallying, and declaration of results in accordance with the provisions of Article 138(3)(c) and 138(10) of the Constitution. Issue number 7, whether the declared president-elect attained 50% plus 1 vote of the votes cast in accordance with Article 138(4) of the Constitution. And number 8, whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. And finally, what reliefs and orders can this court grant or issue? Those were the issues that the court has come up with. Perhaps then we can proceed to the next area. Council present and parties, considering the constitutional time frame for determining the consolidated presidential election petition and the nature of the issues raised, as well as the COVID-19 pandemic, we have limited the number of advocates who can sit in the plenary as per the schedule that was shared with you this morning by the registrar of the court. For further clarity, been asked to clarify that parties have a right to representation of as many lawyers as they wish. The only reason we cannot accommodate everybody here is because of the limited space. We are still in the COVID-19 protocol that requires social distancing, and also because of security. However, on account of all these considerations, we have facilitated additional advocates to sit in courtroom number 1, where the proceedings will be streamed live. I will seek your indulgence on behalf of my brother and sister judges and cooperation in this regard. We have also shared a time allocation that is allocated to each one of you. I believe you have been given a copy of the time allocation schedule. Things are streaming online. If you can check, maybe it has come, but I can read it for you. When we will start the hearing tomorrow, the main petitioner, that is petition number E005 of 2022, Raila Odinga and Martha Karua, we have allocated them 3 hours. The supporting petitioners, being petition number E001 of 2022, John Joroge Kamau, we have allocated that supporting petitioner 30 minutes. Petition number E002 of 2022, Youth Advocacy Africa and Peter Kirika, we have allocated 30 minutes. Petition number E003 of 2022, Kerif Karifa and others, 30 minutes. Petition number E004 of 2022, David Kariuki Ngari, 30 minutes. Petition number E007 of 2022, Okia Omtata Okoiti and others, 30 minutes. Petition number E008 of 2022, Julia Nyokabi and others, we have allocated them 30 minutes. It is hoped that that will be the time allocation for tomorrow, and when we proceed to the hearing of the we've also looked at the responses by some respondents, namely Juliana Cherera, Irene Masit, Justus Nyangaya, and Francis Wanderi, who appear to be supporting the petition. These 4 respondents have been allocated 1 hour to share among themselves. That gives to that 15 minutes each if they are represented by different counsel. Then parties in opposition to the petitions, we have identified IMBC together with the chairman, Wafula Chebukati, and we have allocated them 3 hours to share. William Ruto and Rigathi Gachagua, they have been given 3 hours. The Attorney General will be given 30 minutes to respond. According to the rulings that we have delivered, we admitted 3 amici curiae. They will not be given time to make oral submissions. According to the rules of this court, we will rely on their briefs, which are on record, unless the bench wishes to raise an issue for clarification by them. That will take us now the second day of the hearing. We are hoping the third day, which is Friday, we will hear a rejoinder. We'll give the main petitioner in petition number E005 of 2022, Raila Odinga and Martha Karua, 1 hour to respond. Petition number 001 of 2022, John Joroge, will have 15 minutes. Petition number E002 of 2022, Youth Advocacy Africa, 15 minutes. Petition number E003 of 2022, 15 minutes. Petition number E004 of 2022, 15 minutes. And petition number E007 of 2022, 15 minutes. And petition number E006 will also have 15 minutes. As you will also have noticed, we have given a comprehensive ruling on the applications that were filed seeking discovery, various discovery and scrutiny. According to the order that has been issued, we are expecting a report that will be tabled before this court for consideration by Thursday afternoon. And if there will be issues arising from that report, we have agreed to give the main petitioner 30 minutes to respond. And because they filed an application for discovery, so was Youth Advocacy Africa and Mr. Kerif, they also filed an application for discovery. According to the issues that they were raising, the Youth Advocacy will be given 20 minutes, and Kerif, who was seeking one issue, will be given 10 minutes. The IBC will be given 30 minutes, and William Ruto and Rigathi Gachagua will also be given 30 minutes to respond to the report that will be filed if there will be issues arising which they will wish to respond to. That is the time allocation. Due to the time constraints that we have to determine these election petitions within 14 days, you will appreciate also the filing was tight within 7 days. This is dealing with information or evidence from all over the country. The framers of our constitution decided that they will give 14 days. It has been done before, and we hope to do it also this time. But we will also seek your indulgence when you are allocated your time, you will adhere to the time. We also developed some ground rules as a court, where we are requesting that parties and advocates will observe punctuality, the time that is indicated for us to start the proceedings, and the time allocated to them on the screen. We will also, this is an old practice, that we will continue to be respectful of the court, our personnel, and also to respect each other, adhering to the rules of this court. We also are obliged to state that we expect parties to conduct themselves with decorum to preserve the dignity of the court and the proceedings, while bearing in mind the provisions of Section 28 of the Supreme Court Act. We are also reminding ourselves that these are judicial proceedings being conducted in court, and therefore discussing the merits of the case by the parties or counsel outside the court is not permitted. We still have the power under Section 28 of the Supreme Court Act to cite such parties who are in violation of the provision of the law. We also like to remind you that courtesy must be observed at all the time. The court will not tolerate offensive language. We like to repeat about the time allocated due to the time constraints. Once a party has exhausted the allocated time, the microphone will be switched off. We also wish to state that if there is time that is unspent by the council, the time belongs to court, so we will not allow anybody to donate, but revert it to the court for the court to share it out according to the court's generosity or lack of it. Due to the limited timelines, there will be no extension of time, so please let no one ask for extension of time. We are dealing with the submissions that have already been filed. We have been painstakingly reading those submissions. Therefore, we wish parties to just focus on the key issues that they would like to highlight. Parties are therefore urged to focus on the pertinent points of their case to save on time. We always like to remind parties cell phones must be switched off or on silent mode. During the hearing, unnecessary movement or disruption when the court is in session is discouraged. However, parties or counsel or even the bench are however permitted to take health breaks during proceedings as the need may arise without disrupting the continuity of the submissions. And during these individual breaks, the proceedings will proceed. Even if I want to walk out, don't think the proceedings have stopped. They will proceed.
Okay, Chief Justice Martha Okome, of course, continuing right there to state House rules or what will be followed once the hearing begins tomorrow. Of course, previously we've had her mention that all the petitions have been consolidated into one. Petition number 5 now is the lead petition, with Raila Odinga and Martha Karua named as the first petitioners. Of course, on the other side, William Ruto and Rigathi Gachagua mentioned as the first and second respondents, with IEBC as as the third respondent and Wafula Chebukati as the fourth respondent as well. Looking at 9 issues that have been framed, just to mention a few, of course, issues that will be looked at is whether the technology deployed by the Electoral Commission, IEBC, met the standards of integrity, verifiability, security, and transparency in order to guarantee, what can I say, verifiable results as well. We'll look at probably 2 issues that have also been framed is the interference of uploading and transmission of Form 34As. This is from the polling stations to the IEBC site, as well as finally, what reliefs and orders can the court grant an issue? This is after everything else has been said and done. With me still in studio is Odhiambo B.O., an advocate of the High Court. Thank you so much for being patient with us and still being here, of course, looking at everything that has been mentioned and said by Chief Justice Martha Koome during the pre-trial conference. First of all, I think let's start by addressing the issue of time. Of course, she's clearly stated what is expected to happen from tomorrow and throughout the other days of the hearing. We look at Raila Odinga and Martha Karua given 3 hours, as well as, and the others, petitioners given 30 minutes each. And then we look at the respondents. We see William Ruto and Rigathi Gachagua given 3 hours as well, in comparison to the other respondents, which have limited time or few time. Just to make our viewers clearly understand as well, why is this so, and then also take us through why is Raila Odinga's and Martha Karua's petition the lead petition.
Yeah, first on the issue of time is that Raila Odinga is the lead petitioner, having contested in the election, and he raises a number of issues. So the presumption, the decision by the court to give Raila Odinga that time is because the issues Raila Odinga presents are quite weighty and they need to be considered much more. Not necessarily that the issues presented by the other parties are less weighty, but the thing is that the other petitioners are called supporting petitions. They, in essence, their issues support what Raila Odinga's petition is all about. And you'd note that the main challenger to this election is Raila Odinga, the person who has been elected, whose stakes, so the parties whose stakes are high have been given much time to respond. Right. Rather than these other persons are supporting their petitions and supporting again also in response. Yes.
All right. As we come to a conclusion of today's session, of course, what's your take, first of all, on what is going to happen? What do you make of the procedures or rather the proceedings that are to come? We've had Chief Justice Martha Koome state clear rules on what is to happen in the days to come, of course. Give us a parting shot, of course, as well. Yeah.
Before I part, I would say that I expect an in-depth analysis of issues by both parties, both the petition and the respondents, so that we are able to understand why the issues have been framed in the manner they are framed in, and that the petitioner would make a case for themselves why the court should give them audience and grant the orders they're seeking, and why the respondents would want the court to limit or not grant the orders the petitioners are seeking. In my parting shot, I would tell Kenyans that we have grown of age and we are mature as a democracy, and it is the fact that countries and their observers from the Commonwealth nations observing our processes is indicative that Kenya has become mature as a democracy and is allied to the jurisprudential development across the world. So we need to stay calm, await the process, and be ready to take it as it comes. Yes.
All right. Thank you so much. I think that is very well put.
Thank you.
Thank you so much, Odhiambo B.O., right there, an advocate of the High Court. We do appreciate you big time. As well as to you, dear viewer, who's joined us for the Kirk mid-morning. Many thanks to you for staying with us this far. Of course, the pre-trial conference is ongoing. We have been bringing you pictures of that live. Of course, the reports coming in is that Fernandez Baraza of Azimio la Umoja One Kenya Coalition has been pronounced as governor-elect of Kakamega County, still awaiting to hear results from Mombasa County. Hassan Omar, of course, versus Abdul Samad Nasir Sharif. Right there in the morning, we saw that Abdul Samad was leading with votes from 2 constituencies yet to be counted, so we're still awaiting to hear from that. But for Kakamega County, it is Mr. Baraza. Earlier on, we had seen Mr. Malala making a post, of course, conceding defeat even before the results were officially out. That's it from me today, this morning, Kirk Mid-Morning. Thank you all. Barita Badna, I'm crossing you over to my colleague Vincent Kerosi, who is with Reverend Leanne Degwa, who I hear wears many hats. So as we celebrate 40 years of clergy women ministry today, we get to see a picture of the life of Reverend Leanne Degwa and get to understand how she's able to handle all that, as well as key issues that Kerosi will be able to tackle and handle with her. So Kerosi, kazi kwako sasa hivi kutoka kwangu studioni. To everyone who was able to join us, many thanks. Right over to you, Kerosi. Okay, good. All right, thank you. Thank you so much for today.
Asante.
Julius hapa hakuna maji. Na hapa ukipata bibi. Kwa nini? Hapa ni bibi. Lakini utakuwa dona bibi maji.
We welcome your feedback on our programming. For questions or comments, kindly get in touch with us via email info@kirktv.org, SMS 0111 220044, or call us on 0794 588 054.
When the Bible wants to say something has come to an end, they'll say they waited for 40 years, for 40 days. 40 is an end of a season.
40, if you read the Old Testament, and it even overflows into the New Testament, is fullness.
You know, something continuous, not just because it's 40 years.
To me, is the victory of the church, that the church was able to embrace women.
And so we also celebrate the many men, the many leaders, our church fathers, who actually sat down and said it is time.
It's a moment of rejoicing over the joys and pains that I've gone through.
And I told God I would want to be a minister like this one.
The ones that cleared the thicket in the forest for us.
Because of the sacrifices they made, the battles they fought, you know, their great commitment.
In all humility, there are those who have been called home. They have paved the way for us.
To be with the Lord home, Jesus is still with you.
igoro ti hodo todo erena thina muingi no Jesu ariho rugendo ni rwega tutwa ranete hegi keno.
Apeleke atuambie ni nini baya na hii posho.
Ndio mwana muitafutie solution.
Alafu mnawekelea mbegu unakuwa una
Si mchanga wote unaweza nini?
Hapana. Hapana, si mchanga yote. Si kama hii. Hapana. Hii mchanga si kama hiyo.
Hii ni special soil.
Special soil for
Ama mtazamaji wa runinga ya Kirk, mtazamaji wa kipindi cha Kazi na Mali. Namna gani, hali namna gani siku nyingine ya kuchapa kazi ilivyo kawaida yetu, lakini leo hii tofauti ni kwamba umezoea kipindi chenyewe kuja hewani usiku saa 1:30 hivi, lakini leo tunafanya matao ya chini mapema wakati wa macho ya mtazamaji. Sasa hivi nakaribia saa ngapi? Nafikiri ni mchana dhuhuri hivi saa 6, na mambo yanakuwa mazuri zaidi. Basi sababu gani leo imetufanya tufanye kipindi asubuhi ama mchana huu mtazamaji? Sababu ni kwamba tunasherehekea miaka 40 tangu yule kasisi wa kwanza ama mhuduma wa kwanza kabisa wa uchungaji katika kanisa la PCA wa kike alitawaza na kuanza shughuli. Basi moja kwa moja ndio sababu imetuleta moja kwa moja katika eneo la Githunguri, ambapo tunakuja kuungana na mmoja wa wale wahuduma wa kike, wale wachungaji wa kike katika kanisa la PCA, anayekwenda kwa jina la Rev Lea Ndegwa. Nafikiri nimelipata vizuri, ambaye tumeketi na yeye kitako hapa kwa muda wa dakika kama 40 hivi zijazo, tuzungumze na yeye mawili matatu ili tukapate kuelewa basi shughuli anayoifanya ni gani, mbali na uchungaji anakifanya kingine kipi tofauti ambacho mtazamaji kitakuwa cha muhimu wewe kufaidi ndani ya kipindi cha Kazi na Mali. Karibu sana mamangu.
Asante.
Jina lako ni Rev Lea Ndegwa, nimelipata vizuri?
Kabisa.
Jina la kati liko?
Liko. Mimi naitwa Wajiko.
Wanjiko.
Ila watu wamezoea sana Wajiko, katiba ya Wajiko, nini ya Wajiko.
Kila kitu ya Wanjiko. Kwa hivyo wewe ndio yule Wanjiko ambaye anatumika sana.
Kweli kabisa.
Asante sana kwa kukaribisha hapa kwa mandhari mazuri na pendezo kweli hapa. Manake hapa mtazamaji kumetulia, jua limewaka vizuri, ametuambia kwamba angalau jua leo limetokea, manake siku nyingine huwa ni kibaridi kidogo, lakini leo jua limeangaza kumaanisha kwamba basi siku yenyewe itakuwa nzuri kabisa. Hapa maeneo yanaitwa Githunguri wapi?
Hapa ni Kamushege.
Kamushege.
Kiamagutu. Yes.
Ndani ya eneo bunge la Githunguri.
Hapana, Lali. Hapa ni Lali.
Kwa hivyo si Githunguri?
Hapana, hapa ni Lali.
Unasikia sasa? Nilikuwa nimekosea. Hapa Lari, eneo bunge la Lari, ndani ya Kiamashege. Kamushege. Kiamagutu. Haya. Karibu sana mama. Utueleze mawili matatu kwanza, wewe ni nani? Unajulikana kwa shughuli gani? Alafu tuendelee kutoka hapo.
Kwa jina kama vile umetaja, mimi naitwa Lea Wajiko Ndegwa na nimeokoka. Niliokoka nikiwa msichana mdogo 1975 tarehe 10 mwezi wa 8. Nilikuwa primary school. Na mimi ni mama, nimeoleka, na bwana yangu pia ni kasisi wa PCA. Na hata we were ordained on the same day. That is 13th of March 1993. Yeah. Na mimi ni mama wa watoto wawili vijana. Mmoja anaitwa Samuel Kamunya na mwingine anaitwa Jedidia Wagai. Yeah.
Hebu tuelezee safari yako. imekuwa namna gani? Safari imekuwa namna gani? Maana tunajua kwamba safari hii wakati mwingine milima na mabonde mingi, lakini miaka 39 ni baraka kubwa.
Safari imekuwa
ni si baya. Yesu ametembea, tumetembea na Yesu kwa hii safari. Kwanza nilianzia nikiwa mwinjilisti 1986 huko na Rumoru. Alafu nikaingia kwa college huko lay training, nikafanya diploma ya theology. Alafu nikatumwa Kiratina Parish 1993. I was licensed 12th December 1993. Na hapo nikaanzia hiyo kazi ya huduma hapo Kiratina. Alafu kanisa ikanituma Kirimara Presbytery, nikahudumu kwa mashule kwa Presbytery kwa mwaka mmoja. Alafu kutoka huko nikatumwa kwa parokia, nikakaa kwa parokia kwa miaka kama 4 huko Kirimara Presbytery Ruguru Parish. Alafu kutoka hapo nikatumwa tena Kaboi Presbytery kwa mashule tena, nikahudumu kwa mashule kama miaka 5 ingine. Alafu kanisa ikanituma tena kwa parokia ya Gatamayo, huko nikahudumu kwa miaka 6. Kutoka pale kanisa ikanirudisha tena pahali nilianzia Ruguru Parish. Nikahudumu huko kwa miaka 5.
Ruguru ni Nyeri?
Ni Nyeri, Mathira. Sasa huko nikakaa miaka 5 mingine. Alafu kutoka huko kanisa ikanituma Kaburu Parish. Hapo nikakaa miaka 7. Na leo hii niko Kiratina Parish pahali nilianzia 1993. Yeah.
Huu ni mwaka wako ngapi sasa?
Mara ya pili, mara ya kwanza nilikuwa mwanafunzi akijifunza kazi, lakini sasa ni kama au retire via. Yeah.
Miaka 29 tangu mwaka 1993. Na tunasherehekea miaka 40 tangu kuwe na kasisi wa kwanza wa kike katika kanisa la PCA. Miaka 40 kumaanisha kwamba ndani ya miaka 40 hii wewe umekula miaka 29. Hebu tuelezee huduma kwa upande wa wanawake wakati ilikuwa namna gani? Si tu kanisa la PCA, lakini wanawake wachungaji, wanawake makasisi katika tu huduma ya Kristo ilikuwa namna gani wakati huo?
Mwanzo ilikuwa na shinda kwa sababu si wengi wageamini mama aweza fanya huduma kwa parokia. Huko mwanzo walikuwa natutuma kwa mahospitali, kwa mashule, lakini sasa kumebadilika sana. Na hapo mwanzo kulikuwa na shida nyingi sana. Juu kwanza pale nilitumwa sikuwa na gari, sikuwa na nini, na nilikuwa na mashule kama 60. Na inabidi wende kwa hiyo mashule yote. Na shinda nilikuwa nao nyingi sana. Kwenda kwa mashule haikuwa rahisi kwangu. Juu mimi I'm not an educationist. Kwa hivyo ni kujifunza, unafanya kazi na unajifunza vile utahudumu pale. Na unahudumia walimu, wale wanabodi unawahudumia, wanafunzi primary and secondary. Kwa hivyo haikuwa rahisi sana, lakini Mungu alinisaidia na nikafanya kazi mzuri sana. Kwanza huko Kirimara kwa mashule na Kamboi nilifanya na Mungu akanisaidia sana.
Tutazungumzia, utueleze mawili matatu ambayo uliyafanya wakati huo ambayo ilikutia moyo mpaka ukafika mahali ambapo umefika. Lakini kabla tufike hapo ni vizuri tuangalie pia jamii ilikuwa inawapokea namna gani wakati huo. Maana tunajua kwamba kuna jamii nyingine ambapo mwanamke kufika cheo ama ule wadhifa wa kusimamia hata kanisa ama kikao fulani wakati mwingine ni mohali, wakati mwingine ni mwiko, lakini tamaduni na mila wakati huo ziliwazuia ama zilifanya namna gani, nyinyi ziliwaathiri namna gani katika shughuli zenu na huduma yenu?
Hapo kwa utamaduni hapa Central si sana wanatuitikia vile tuko kama mama, na wanatuelewa na wanatuchukua vizuri, na tunatembea pamoja vizuri juu. Na hata pahali kulikuwa na wanawake wa kwanza kuwa ordained kama elders ni huko Tumutumu, na hapo ndipo nilitoka Tumutumu. Kwa hivyo
nikiuliza Julius hapa hakuna maji. Hapa ukipata bibi, kwa nini? Hapa ni bibi. Lakini utatoa siona elimu mfano.
Kuwa moderator wakati mmoja huko Kirimara, na hata karani wa Presbytery Kiamadhare, Kithuguri, na hata huko Kirimara kama karani wa Presbytery. Hata kuna wakati nilikuwa member wa business huko, lakini ni kungangana. Ni kungangana.
Na kweli hao ni majukumu makubwa, maana katika basi kamati ya kuangalia ya kuendesha shughuli za kanisa ambayo ni business committee si rahisi. Ni jukumu kubwa hilo. Lakini unaweza kukumbuka mmoja au wawili ambao waliwashika mkono wakati huo mkianza nyinyi ni akina gani? Unaweza wakumbuka wale waliwashika mkono, maybe wanawake wenzako ama hata upande wa majana dume, wanaume ambao waliwashika mkono?
Mmoja na si Mkikuyu, ni Mmasai, anaitwa Olelila. Huyo mchungaji amenishika mkono hata wa leo. Ni kama baba kwangu.
Yupo hai bado?
Ako na ni msee mzuri sana. Na unajua yeye ni Mmasai. Na anashika mama na anasema huyu mama atafanya na atafanya huduma kwa kanisa. Huyo ni mmoja. Mwingine ni one of our church father, Reverend Dr. Jesse Kamau. Yeye pia ni kama baba kwangu. Alinishika. Na hata his father-in-law was the one who gave me the practice and procedure wakati nilikuwa mwinjilisi. Na akasema wewe siku moja utakuwa mchungaji. Akanipatia hiyo kitambu. Kwa hivyo hata akiwa alienda, na shukuru Mungu juu alinifanya niwe vile niko. The father-in-law of Reverend Dr. Jesse Kamau anaitwa Hemdan Githaiga. Alikuwa mzee wa kanisa na hata alikuwa chief wa kwetu.
Huyu tunayemzungumzia naye hapa ni Lea mchungaji. Sasa tuzungumze na Lea mwingine ambaye si mchungaji, na ni Lea ambaye anafanya shughuli nyingi tu. Shughuli kubwa yako ikiwa ni ukulima na ufugaji. Hebu tuelezee kwanza vipi kuhusu shughuli yako unayoifanya, ukulima na ufugaji? Maanake hapa tumekuja, tumetembea kwenye shamba lako, tumeona kuna mimea mingi tu, kuna mifugo wengi tu ambao umewafuga. Hebu tuelezee kwanza ulitoa wapi huu upendo ama mapenzi ulionayo kwa ufugaji na ukulima? Ulianza kitambo ama umeanza majuzi tu?
Unajua mambo mengine ni kama kusaliwa na ukiwa na hiyo kitu ndani yako. Huwezi ukaiashiria, unaona tu unatembea na hiyo kitu inakufuata. Kama hii farming ya mifugo na hata ya shamba, mimi ninajikuta tu nikipenda hiyo kitu sana, na imetusaidia kama familia sana hii ya house greenhouse farming. Hiyo imetusaidia sana na imetutoa bali, na tulianzia tukiwa huko kwetu Nyeri juu hii shamba inaitwa shamba B, kuna ingine iko Nyeri shamba A, na huko tunaweka havers sikifikisha muda sikishua kama tunawauza, wanatusaidia. Kwa hivyo niseme ni kama ukulima ni kama hobby. I just like farming. It's part of me. Kwa
hivyo wakati umetoka kanisani jioni umepiga huduma kuja sasa kuanza kuingia shambani kwako?
Hata na inanisaidia sana juu wale tunafanyia huduma kwa kanisa ni farmers. Kwa hivyo inakufanya uelewe shida zile wanapitia kama farmers. Unajua tunaambia members ni lazima watoe fungu la 10. Sasa ukiona member hatoi na ni farmer, unaelewa shida yake. Ikiwa ni mifugo iko na shida, unamuelewa. Ikiwa ni hizo greenhouse pengine hakuna market, unamuelewa. Kwa hivyo inanisaidia hata kutembea hii safari na member na wale watu na washirika wangu. Yeah.
Naam, hebu tuzungumzie sasa ni nini hasa unakifanya hapa? Kiuchumi, ni kipi unachokifanya hapa? Maana tumetembea kule shambani ndio.
Kuna
mtazamaji elewe hata tunapocheza zile picha ambazo tayari tumezichukua kule.
Tuna greenhouse na tuna capsicums ile ya yellow na ile ya red. Sasa ni wakati wa kupanda. Mmekunja wakati tushauza zile zilikuwa, sasa tumeanzia tena.
Capsicums ni hoho.
Ni hoho ile ya yellow na ile ya kiwa na 5-6 tunauza. Lakini sasa tunasema hebu tujaribu tuone masiwa itatupeleka nje. And they are doing well. Yeah, tunashukuru Mungu pahali tumefika.
Kweli kabisa, manake tumekuja hapa na kabla tuanze kipindi tumepewa chai tamu sana kweli. Na maziwa yenyewe kiukweli yako ya dukani yale ya kununuliwa, manake yalikuwa moja kwa moja maziwa ambayo ni mwanana ama fresh kutoka kwa hawa ng'ombe ambao wamefungwa hapa. Kwa hivyo anachozungumzia mchungaji hapa si neno tu, manake ni ukweli, tumeshuhudia, sisi wenyewe ni washuhuda. Lakini tuanze kuzungumzia sasa kimoja kwa kingine. Hasa kabisa tuzungumzie ule ukulima ambao ni wa greenhouse. Kule ndani umezungumzia kuna hizi pilipili hoho panda ambazo ni za rangi ya
red.
Rangi ya
sinaitwa red night. Na hizo zingine ni yellow.
Mbona ukachagua hizo na si nyingine? Maana najua zipo hizi za kijani kibichi.
Hizo zingine hazina bei, hazina pesa. Na alafu watu wengi wanakuza hizo. Kwa hivyo hazina market ile ungetaka. Lakini hizi zingine ya red yellow, market is always available. Iko. Wakati wowote. Na iko na bei mzuri. Kwa kilo wakati tuko nazo, kwa kilo tunauza kutoka 90 shillings, 100 or 110, 120, even 140. Yeah.
Hivyo soko lake lipo sana.
Lipo kabisa. Alafu kwa wakati wa kolendi una harvest kila wiki. Kutoka kilo kama 250 to 300 in a week.
Kile kijichuma ambacho
Kwa hivyo lovely, in a week you can get allowed 20 to 25,000 to 30. Na una harvest a whole year. Yeah, every week.
Kila wiki unazo shilingi zako 30,000.
Ama kutoka 20, 25 mpaka 30,000.
Tuseme 20,000
kila. Yeah. Kila wiki.
Kuna majuma 54 ndani ya mwaka. Hivyo ukipiga hapo ni zaidi. Si mchanga wote unaweza nini?
Hapana, si mchanga yote. Si kama hii. Hapana. Hii mchanga si kama hiyo.
Hii ni special soil.
Special soil for
wewe unaita aje hii soil?
Unajua? Iko na jina lakini sikubuki. Iko na jina. Weka mbegu. Unaweka kwa hiyo tray. Alafu unawekelea mbegu. Unakuwa
si mchanga wote unaweza nini?
Hapana. Si mchanga yote. Si kama hii. Hapana. Hii mchanga si kama hiyo.
Hii ni special soil.
Special soil for
hatua gani ni yapi ambayo yanafaa kufanywa kitabia ili kuhakikisha kwamba mkulima anafaidi?
Lazima mchanga uwe na agronomist akuja angalia mchanga aone kama itaandamana na hizo, alafu ujue ni si ile mbegu mzuri ya your area, alafu ujue madawa ile utatumia. Kwa sababu kuna madawa ambao ni baya ni mbovu kwa binadamu, na inauzwa tu kwa maduka. Kwa hivyo ni lazima ujue juu kila kitu kila unapanda ni lazima hata pia wewe ukule. Yeah.
Na zile pilipili zinaweza kupandwa mahali popote. Si lazima ziwe ndani ya chumba.
Hapana, hizo ni lazima ziwe ndani
ya kile chumba. Ukipanda nje ni kipi kitatokea? Kumbe lazima ile conditions zikuwe moderated pale ndani.
Na madhara ingine ya magonjwa.
Kwa hivyo ni kule ndani.
Ni kule ndani, hata wakati mwingine si lazima mtu wote aingie huko.
Na umezungumzia baada ya kuwa tayari, sasa ni mwaka mzima